Hello, my name is attorney Shon Douctre. I'm an attorney with over 10 years of experience representing people accused of DUI in Central Florida. I know how you feel. You're probably scared and you don't know what to do. You want to just put your head under your pillow and just forget this all happened, but you got to get on your horse, you got to get moving, you got to get a lawyer. There's deadlines in a DUI case, there's deadlines with your license, and you don't want to miss any deadlines and put yourself in a worse position than you're already in. So this is where I come in. This is where I'm going to help you. I'm going to guide you. I'm going to tell you what you need to do. I'm going to give you like a roadmap to success. On your case, it's going to depend on what prosecutor you have, what judge you have, what court you're in, when your court date is. All these things are going to be a factor in helping you come up with the best possible approach to your case, because not all DUIs are similar, or I'm sorry, not all DUIs are the same, but they are similar. You are probably like anyone else. You were driving down the road and maybe you got into an accident, somebody stopped in front of you, maybe you were speeding, or maybe your tag light was out. Something, you're sleeping in your car trying to do the right thing, something caused a police officer to encounter you. You're probably just going on your way, maybe you're probably going home, maybe you're close to your home, you're almost at your destination, and all of a sudden your life starts changing. A police officer comes in to the scene, or somebody gets called, somebody calls the cops, and now a police officer is there in your face asking you questions. So if you're like anyone else, you want to comply, you want to do the right thing, you're a good citizen, maybe you've never been in trouble before, you don't know how to react. So you start, getting your paperwork out, and then the cop puts in the police report that you fumbled your paperwork, or you fumbled with your license, or you dropped something, or you were swaying in your seat, or maybe when you got out of the car you were swaying. They're gonna put things in the report that are innocent factors, but they're gonna attribute everything to you being impaired or drunk or high or something like that. So things they're looking for when you're in your car is fumbling for the paperwork, fumbling for your license, passing over your license, passing over your paperwork, not noticing things, um, not looking at them when you're talking to them, or an odor of alcohol in your breath and bloodshot eyes, maybe a wristband, things like that, or open containers in the car. So those are the main things that they're looking for, and they probably tagged you on some of those things in your particular report, whether you did them or whether you didn't. They nitpick everything. But nonetheless, at that point, they're going to make a determination and start asking you questions. Have you been drinking? And then you, being the good citizen you are, would probably say, yeah, I had 2 drinks, or yeah, I came from a bar, or maybe you say, no, I didn't have any drinks, because you had the drinks so far, in advance of being pulled over, that you really didn't think that, you were drinking per se. You were just coming from a drinking event. You maybe had drinks at lunch. So you say no, but you still have an odor of alcohol on you. But nonetheless, as soon as you admit, yes, I've been drinking, whether it be 1 beer, 2 beers, 3 beers, or coming from a bar, or anything like that, you basically invited yourself into a DUI investigation, because no cop is going to sit there and hear that you had something to drink, maybe notice some factors of you in a car, and then say, okay, get out of here, go home. And then you run into someone, and now they're going to get fired. So procedure is, you admit to drinking, you're getting out of the car, you're doing a DUI investigation, but they can't really make you do a DUI investigation. Field sobriety exercises, that is. They could only ask you for your consent. There are rare exceptions, like if it was a serious bodily injury, crash, or something like that. But in the vast majority of cases, you have to give consent. So you, being the good citizen you are, you're trying to help your situation. Maybe you didn't think you had too much to drink. Maybe you thought you could pass. So you try to comply, and you say, sure, I'll take the field sobriety exercises. Well, they're field sobriety exercises. They're not tests, meaning there's no pass or fail on those. So in the state of Florida, they're completely subjective. So one cop could look at you and find enough factors to arrest you. Another cop could look at you and possibly let you go. It's really unfair. But nonetheless, that's how it's set up. It's set up for you to give consent, for you to fear your license being suspended, even though they cannot suspend your license for not taking the field sobriety exercises. They can suspend for not taking a breathalyzer or blood test, but as far as the roadside exercises, they can't. But they don't tell you that, and they probably didn't even read your rights, probably didn't give you any indication that you were under arrest or about to be under arrest, and then you said, sure, I'll do the exercises. Well, next thing is they usually pen to the eyes. What they're looking for is that you're turning your head when they tell you to keep it straight, or that you're doing an orbital sway, or you're leaning, or you're interrupting them, or something along those lines. Plus, they're looking to see whether your eyes are jerking. It's called horizontal gaze nystagmus. If they are jerking, which the vast bulk of police reports says that the person is, there could be normal reasons why the eyes are jerking. It could be lights behind the cop. It could be car lights going by. It could be a variety of different things that are causing distractions. They're going to say that that wasn't a distraction, but the reality is it probably was. Because not everybody has nystagmus when they're drinking, not every single person. So, and that's just a clue. It's a possibility. It's a probability to strengthen their case that you are in fact drinking, especially if you deny drinking. So the next thing they usually do is the walk the line test, or exercise, should I say, because there is no pass or fail. So they put you in a start position, and they usually trick you because they put you in a start position, and then they say, okay, hold that position, heel to toe, on the line, and then they start getting into all these other, you know, stay here, put your arms down at your side, walk the line, take 9 heel to toe steps, turn this way, keep your foot on the line, put your hands down at your side, count out loud. Start giving you all these other exercise rules, and then you come out of the start position, and then they put that against you, and then they put you back in the position, and then you take the steps, and maybe you didn't hear because cars are going by, or the cop's talking too fast, or you're just nervous, or maybe you look down to put your feet back on the line and you miss a clue. You miss an instruction, and all of a sudden you're making that mistake too. Most people will get down the end of the line and then stop and turn around and look at the cop and say, do I keep going? Because they forget he said turn around and come back, or maybe you're just being cautious. Nonetheless, that's a common mistake. Turning the wrong direction is a common mistake. Turning an improper way is a common mistake. But nonetheless, these exercises are designed where you're probably going to not do well on them, no matter how good you are. No matter how careful you are. Whether you've been drinking or you're not, you're probably not going to do great on those. And it's going to give the cop the subjective impression that they could arrest you if they want. Because this is how they want. They want the officer on the side of the road to have the discretion to arrest someone or not arrest someone. So if they make the exercises in such a way where almost you always make a mistake, then there's always going to be cause to arrest you if they want, and there's always going to be something there to lead to the next exercise, which would be one-legged stand. Most people can't stand on one leg for 30 seconds. One of the common mistakes with the one-legged stand is they'll start giving you the exercise, and then they'll say, if you go ahead and put your foot down, just pick it back up and continue where you left off. So you, following instructions, will count 1001 to 1010, and then maybe you put your foot down, and then you pick it back up, and then you go to 11 and 12 and 1013, and then you get to 20, and then you put your foot down, and you pick it back up, and before you get out of jail, and you look at your report, and it's counting you off for putting your foot down when he told you or she told you you could put your foot down. Well, it's like Simon Says, and they're just continuing to give you instruction after instruction so they could find probable cause to arrest you and mistakes in the report. Now, had you refused the roadside exercises, they would have probably said, well, we're going to use that against you and arrested you anyway, but there would have been less evidence in your case. You would have just looked like maybe, perhaps, you had something to hide. Other than that, that was your right if you refused the roadside exercises. So now, there's 2 additional exercises that they give people called the finger to the nose and the Romber alphabet test. Those are alternative exercises. They're non-standardized, and they have even more discretion on those exercises because the clues aren't really laid out as to what they're even really looking for other than straight up finger to the nose and proper hand, and alphabet is alphabet. So, but nonetheless, they will use those exercises in the event someone usually says something like, they have back pain or leg problems, broken ankle, sprained foot, something like that where you can't stand on one leg and you can't walk a straight line. So then they'll move to tests or exercises regarding your arms or the alphabet, which you don't need your legs or back, you're just standing there. So nonetheless, at some point you'll conclude the exercises and the officer makes the determination that you're impaired, and then they arrest you for DUI. If you're under 21, they'll give you a breathalyzer right there on the side of the road on a portable one. But if you're over 21, They're going to take you all the way to the jail, and they're going to put you on an Intoxilizer 8000, which presumably is more accurate than the portables. And you probably thinking to yourself, wow, I didn't get a breathalyzer before he arrested me or she arrested me. Why was that? Well, that's just how they do it here in Florida. You usually are asked whether you want to take the breathalyzer on the way to jail or once you get to the jail. And chances are you didn't get read your rights. They don't have to read your rights on a DUI in Florida unless there's a crash, an accident. So if there's an accident and you didn't get read your rights, you've got a much better case than the average person. But if it's just a regular DUI, sleeping in your car, speeding, got pulled over, weaving, whatnot, no serious injuries, nothing bad, then they didn't have to read your rights, unfortunately. And that is really there to get you to not invoke your right to an attorney and to take a breathalyzer, because if they start reading your rights, then you're probably going to shut down and then invoke your right to an attorney. So they purposely leave that out, so you will once again give up evidence against yourself and take the breathalyzer. Once you get to the breathalyzer center or the police station where the breathalyzer is, they're going to watch you for 20 minutes, make sure you don't burp or regurgitate, so that'll affect the machine, the validity of the sample, so they want to make sure there's nothing in your mouth, no gum, and then they're going to ask you to take a breathalyzer, or they're going to suspend your license for a year. Most people will choose to take it, but about half refuse anyway. If you refused, that could be good. If you took a breathalyzer, that could be good, because not all breathalyzer samples are valid. I'm a breathalyzer technician and maintenance operator, so if there's any way possible to pick apart your machine, I'm going to be able to find the silver lining as to your particular machine, whether maybe the machine just went out for maintenance the week before, maybe the guy after you, there was some kind of a flag on the machine. I'll be able to look at all the records prior to you and post you, see when the machine was certified, when it went to warranty. I mean, had cases where the machine broke two days after the person took the breath test, and the machine never came back into service because there's a problem with it. Any of these reasons could void your breath test. As far as a refusal, if you refuse, you refuse. And then there's the rare cases where the person tries to blow into the machine and they don't blow hard enough, and then they just call it a refusal, even though the person tried. And I like those cases too. But regardless of what type of case you've got, refusal, attempted blow, or blow and blow over, or whether you blew zeros and they ask you for a urine test, either way, there's always ways to help the case improve. And then at that point, they turn you over to booking, and you come out of there with either a police report or a DUI ticket or both, and then you come home and you think, what happened? What am I going to do? And then you start looking for lawyers. Well, you found me. I want to help you out. This is what I do. It's my passion. I love helping out people with DUIs because it could happen to anyone. Please give me a call. I'm looking forward to helping you out. Thank you.